costs at the end. That's again a very broad question, but the starting point would be that the general rule is that the loser pays the winner's costs. So if an applicant succeeded with their claim, you would expect the court to order that the beneficiaries contesting it have to pay a reasonable proportion of their costs. And there are obviously lots of variables on that, and the court has a very wide discretion as to what order it can make on costs. The parties can also reach any agreement they want between themselves through negotiation. And there are also kind of lots of other factors, like if certain types of offers are made, or there's unreasonable conduct by the parties. Those are all things that may sway the court to make a cost order in favour of one person or another. But the really important thing to bear in mind is that we're nearly always talking about one pot of family money, and all the costs are going to come out of that pot one way or another. And the higher the costs and the longer it goes on, the more that pot is going to be diminished, and the less there's going to be for everyone at the end. So the thing we always try to stress is that it's in everyone's interest to try and resolve the dispute without proceedings as quickly as possible. If it's all possible, often that isn't possible, but that is obviously the most desirable way to try and approach it and to try and resolve it, because ultimately it's best for everyone. And just on the second point then, which is obviously linked, it's what happens if my claim is contested by my family. And so what I would say on that is that it is very common for a 1975 Act claim to be contested by the existing beneficiaries, because if you think about it, a claim under the 1975 Act is essentially trying to take money away from those beneficiaries for the applicant. And so those beneficiaries, who very often are family members, have a direct financial stake in the claim and it not succeeding. And so because of that, they can often contest it quite aggressively. It's also worth being aware that even if it's not contested, the claimant still has to prove their claim to the court. And so they're not going to succeed by default just because no one actively actually contests the claim. They still have to prove to the court that the lack of provision is unreasonable, and beyond that they have a reasonable need for maintenance or provision from the estate. And so in practice then, if the claim is contested, what will happen is once the claim is issued, the defendants, who would be the beneficiaries, would put in evidence responding to the claim within the timeline after they've served with it. That response would usually be something along the lines of that the lack of provision isn't unreasonable, because they might, for example, say that there was some estrangement, or that the deceased knew that that person was financially secure, and so for that reason didn't give them anything. On that same note, they may say something along the lines of that person has no need for financial provision because they were never maintained and they've been able to take care of themselves, and they can continue to do so. They may also try and say that they've got their own needs which are higher and competing, and that for that reason it's not fair for the court to take provision away from them and give it to the applicant. And so, as I said previously, most cases settle because of the cost, the risk, and just the general stress. Where they don't settle, it ultimately would end up at a trial, and it would be a case of the applicant putting forward their evidence, any family members putting their evidence in response forward. The court would then weigh all of that up and ultimately decide on the balance of probabilities, whether the lack of provision to the applicant is unreasonable, and if so, the level of provision that's reasonable for them from the estate. And all of this, and just the general kind of contentious nature and stress, is something that clients really need to be aware of, because ultimately, in most of these cases, it is a case of sibling against sibling, sometimes parent against child, and it can be really stressful. And people have to be aware that they are potentially breaking family relationships beyond repair by bringing a claim, and sometimes that may outweigh the benefit of the money to them. But having said that, what I would say is that in my experience, most people, when they come for advice, are already at a breaking point with their family anyway, and so it's not often an issue. But it is something to bear in mind, because these cases are notoriously very emotive and very taxing and stressful on the people involved.